Human jettison, contribution for lives and life salvage in Byzantine and early Islamic maritime laws in the Mediterranean. In his mission to Nineveh, the capital of Assyria, the prophet Jonah recounted how his ship was caught in strong storm and rough seas which forced the sailors to cast personal effect and cargo overboard to lighten the vessel. But the Lord let loose a hurricane, and the sea ran so high in the storm that the ship threatened to break up. The sailors were afraid, and each cried out to his God for help. Then they threw things overboard to lighten the ship. At last the sailors said to each other, "Come and let us cast lots to find out who is to blame for this bad luck." So they cast lots, and the lot fell on Jonah. Our biblical story, which is also recounted in Quran, Yunus 10, proves that following the ship tackle, cargo, divine laws permitted the jettison of human lives into the sea under adverse circumstances for the sake of saving as large a number of sea travelers as possible, a practice that subsequently preoccupied with some discrepancies Roman, Byzantine, and Muslim juries for many centuries. Despite the insufficient legal discussion in the Romano-Byzantine diges and unprejudiced treatment in Islamic jurisprudential references compared with mercantile commodities, lawyers from both societies expressed controversial judicial opinion pertaining to human jettison with the aim of rescuing as large a number as possible of periled travelers and crews stranded at turbulent sea. The cardinal issue which opposed to themselves was how the decision should be made prior to casting human life, who among those on board, crew, servant, ordinary passenger, shipper, and slave, should be thrown overboard in the first place when the danger is imminent, and why? The shipmaster and his crew, according to the digest, were required to deliver the human cargo or slave safely to the prescribed destination. Where the shipmaster failed to do so or injured it, he and his crew would on accepted principles be liable for the losses. In the absence of dereliction, however, the captain and his crewmen were absolved of liability. Thus, if a slave was injured in transit, even if the injury healed, the captain was accountable to the merchant. If the slave's injury was chronic or permanent, the captain was held liable for his or her price, even though the value of slave differed according to the purpose for which they were purchased. Roman and Byzantine lawyers fixed the exact amount of the slave contribution in the digest. However, they make the legal distinction between slave as commodities and slave as private possession by exempting the owner who buys a slave or slaves for private use from import duties at port. The problem of human jettison is scarcely dealt with in the Justinianic digest, which doesn't necessarily mean that human beings were not jettisoned in time of peril. On the contrary, a careful examination of the digest proved that the issue of human jettison was familiar to the Romano-Byzantine legislator, although he didn't explicitly revert it. In the Digest 12, the lawyers make a clear distinction between slaves who fall sick and die naturally and those slaves who voluntarily cast themselves into the sea trying to escape. No estimate should be made of slaves who are lost at sea any more than were those who are ill die on the ship or throw themselves overboard. Possibly this quotation refers to slave forced to abandon the vessel as well. The slave merchant or slaver or owner could not claim contribution for a deceased or runaway slave, but might do so if his human cargo was jettisoned for the general safety of the ship, its crewmen and freemen. The amount of loss had to be distributed in proportion to the value of the property, provided that no appraisal be made of the person of freemen. While free persons were categorically excluded from general average contribution, the digest included slaves in the calculation of the general average, since they came under the heading of things. The question of when to throw human beings overboard, and if so, whom, remained unresolved in the Rhodian Sea Law. Save for some insignificant modification regarding the assessment of the jettisoned slave that will be addressed subsequently, Byzantine jurists largely preserve Roman maritime custom. Both collections of law distinguish between slave acquired for commercial purposes and those for private services. The latter were worth more. For example, a slave who served as peculium, manager or operator on board ship had the status as a captain. He and other operators of the vessel, were they freemen or slaves, could not be cast into the sea because the vessel could not sail without them and their nautical experience. The digest authorizes the peculium, after consultation with the parties involved, to cast cargo and passengers overboard for the safety of the ship. If an altercation arose between the peculium and the shipper, legal allegations were brought against the ship owner rather than his employed slave. Islamic law provided more detail on the issue of forcing human beings to abandon ship under extreme danger. Although the subject remained controversial, most Muslim jurists opposed the practice, and condemnation of human jettison was widespread. Al-Qarawi opposed throwing any human being overboard in any circumstance. The Maliki jurist Shahnun held a similar view, as did the Andalusian jurist Ibn Hazm, who prohibited it even if the matter dealt with captives of the polytheists. Ibn al-Jaham forbade sacrificing self for the sake of others due to the tacit prohibition in Islamic law. Another group of jurists approved of sacrificing some lives if it would save a larger number, regardless of the ethnic, religious, or social allegiance of the individuals on board. However, when there was no choice but to force some passengers to abandon ship, they had to be treated equally and chosen by lot. Al-Qadariyat dictated, aside from commercial commodities, if there were only passengers left, they were, after the victim had been chosen by lot, indiscriminately subjected to being thrown overboard, regardless of their social status and allegiance, whether they were males or females, slave or freemen, Muslim or Demis. Al-Qadr Clyde present further legal opinion of Maliki jurists, stating, Abu al-Hazan al-Lakim decreed concerning the jettison of possession, including slave, regardless of whether they were purchased for commercial or private purposes, all of them are subject to contribution. If they sailed in the vicinity of the coast, or the vessel was shaken fiercely by the wind and the ship owner managed to face it up, then it is prohibited to jettison a slave. Had they sailed far from the shore and the slave owner cannot swim well, or his overweight cannot keep him afloat, the slave should be considered for jettison. Muhammad al-Mawas decreed, on the basis of this precept, one should take into account the distance of a vessel from the shore, as well as the capability or incapability of slave to swim. The same rule is pertinent to freemen for those jurists who apply this ruling to them. Al-Lakmi stated, the law school jurists agreed upon the exclusion of freemen in the calculation of the general average. Moreover, the responsibility for the losses doesn't rest on their shoulder, regardless of whether they have cargo on board or not. However, some jurists embrace by analogy the doctrine that they are held liable for the losses, since jettisoning someone's cargo saved the life of those who did not have commodities on board. Ibn Yunus also rules that this is the correct legal reasoning. Al-Lakim say too, it is more appropriate to include the slaves who were acquired for private possession and commercial purposes. If it were a female slave, her master has no other choice, either by converting her through marriage or keeping her as an infidel. Thank you.